Good evening and welcome to an amazingly exciting topic and a panel that is perhaps even more exciting than the topic itself. Thank you so much. First of all, I'd like to thank Deepak for putting all of this together, for being able to impress all of you for being here. And we are so excited to have you here. This is a conversation which, as we all know, is something that we should be having not just today, but we should have been having for many years past. Many of you may not know, till about a decade back, I used to run a Hindi search engine.
Called Raftar.
Called Raftar, that's correct. And for many years, it did really badly, of course, until I shut it down. But in the process, the one thing that I learned there was the amazing strength that, of course, new technologies have and how Google straddles that space. Eventually, the best way to get out of the Hindi search engine venture was to make it into a Hindi content website and run on Google's largesse, Google's algorithms largesse. And of course, we had some success there. But in the process, what we figured was how difficult it would be for newer entrants to be able to put together the kind of expertise, capital, networks, connections required for entry. Now, I was trained as an economist. So while all of my colleagues used to keep on criticizing Google, I was the one who said that, we exist because of Google, not despite them. So despite the fact that Google's algorithm created all kinds of hassles for us, the fact was that it was a great service, great service. It's a really amazing, how do I put it, amazing problem, a very serious challenge that's there before us. How do you try and figure out whether this is good or bad, whether this is desirable or not? How do you address the challenges? What tools do you have to address these challenges? Do we really have the mechanism to monitor this properly, leave alone try and control it? And I'm sure that those are the kind of issues that this panel will be deliberating upon. So once again, I will not stand between you and this amazing panel, as I said. Thank you so much, and I'll hand it to Deepak for taking this forward. Thank you.
Thanks, Lavish. Am I audible?
Yeah.
Okay. So welcome, and it's on a Friday late afternoon, early afternoon, depending on how far you have to travel. Like it's coming all the way from Nadar University, quite far off from here, and where some people have come close by. But this particular discussion, if we overall see, and today happens to be a Friday, and so was it on 8th of January 1982. And that day, two important things happened in terms of antitrust in the US. One was that the IBM as well as the Department of Justice, both of them made an application to the court, which is technically it's called as application for stipulation for suspension of the case, basically closing the case. And that case itself had started on 17th of January 1969. So almost 13 years after the case was started, both parties spent a lot of time and effort and sweat and blood. And finally, it came to a closure at that time. Now, if you see, by 1982, we already had PCs in the market. So whatever were the, let's say, the potential harms and the concerns in 1969 around mainframes were no longer there by 1982. And of course, there were companies like Apple and few others that had already come up. Even a company like Microsoft, where I used to work much later, of course, was also around in terms of software, etc. Something else happened a couple of years later. On the same day, in fact, on 8th January 1982, there was also something in terms of AT&T. So a company that was established almost a century back, that company reluctantly agreed what is subsequently called as the world's largest voluntary divestiture. So this one company called AT&T got split into 8 different companies. One was called Marbell, which was doing long distance business. And there were 7 baby bells, 7 smaller companies doing in different regions of the country, doing telecom services. Now, that happened again on 8th January 1982. In 1984, of course, this whole thing around AT&T actually came to a fruition in terms of actual demerger, etc., of their assets and businesses, etc., by that time. And in 1984 Olympics, when Carlos was doing the 100-meter world record that he broke that day, there was a guy called Samuel Ginn, who was the CEO of Pactel, which is Pacific Telecommunications Company, one of the baby bells. And he was making a call on a $3,000 mobile phone to someone that, okay, this is what has happened. And today, if you see where we are. So what happened when AT&T's problem was being looked at, wireless communication of cellular was nowhere on the horizon. When IBM was being looked at, PC was not being looked at. Few years later, what happened? In 1995, there was a company called Netscape. They launched a browser called Navigator, Netscape Navigator. That was the first commercial browser that became very popular. They had a fantastic IPO. That's what actually created this whole boom around the .com, which fueled for next 5 or 6 years. Now, what Netscape did, Netscape became very popular. Microsoft was not at all in the browser business till that time. In 95, Microsoft also said, okay, fine, we'll also pivot ourselves towards this. They launched Windows 95 and they bundled Internet Explorer as part of the Windows operating system. And this is something that led to a situation that most of the people who were otherwise paying to Netscape for a browser, they were no more interested in paying anything to Netscape. So Netscape made a 22-page application, and that's what led to another litigation in terms of antitrust. And finally, there was a decision, and Microsoft went for a consent decree. They agreed to do certain things, not do certain things, etc. Now, by the time this whole thing happened, something else had happened. 2 students at Stanford, they started Google as a project. Company was not even incorporated. Few months later, the company got incorporated, and the competition basically came from a totally different angle. It did not come from a different browser. It did not come from a different operating system. It came from a search. Now, on 14th of August, 16 days back, and this, I would say, was a fairly speedy trial in the US. So the case started in 2023, and Justice Amit Mehta, on 14th of August, he said that Google is a prima facie a monopolistic organization, and of course, what remedies might come will follow perhaps in future. It may take a few months, maybe a year or so. By the time they come to some specific remedies, whether they do divestiture, whether they do breakup, whether something else. But something else has started a few months back, which is a lot of people, instead of searching online through Google or Bing, etc., they have started using AI. So what's happening is that, yes, there's a certain construct of a market in a certain manner. And by the time this whole investigation and econometric analysis, etc., legal work, etc., goes on, we have a situation that something else comes from a totally different vector of competition, and suddenly this whole thing gets upended. So that's the one area that I just want to share. Second thing happened in India. So the Ministry of Finance, they have a standing committee in the Parliament, Parliamentary Standing Committee on Finance, and because the Ministry of Corporate Affairs also is dealt by the same committee, last year in July they came up with a report on digital competition, and part of that was they listed 10 different types of harms in terms of price discrimination, in terms of advertising, etc. And then they said that we should look at digital in a totally different manner. And then soon after, the government formed a committee, and that committee's report is already out. It's out for consultation at this point of time. They've also come out with a draft competition law bill for digital space itself. Of course, a few years back, and the current finance minister, who was also then the finance minister, she had mentioned this even at the CCI's annual event, and some of us were around at that event, where she had said that in digital markets, you may have competition, which is number one, which is not necessarily related to price. It could be something else. Secondly, it could also be in terms of cross-border entities. And that's something where we want to have a digital markets unit, which, by the way, CCI has already started that process. But this is in this background that we just want to explore few issues. One, every sector has got some peculiarities, whether it's digital, whether steel, cement, etc. So are these type of peculiarities good enough reasons to have a separate type of legislative or regulatory approach only for that particular sector? So that's one. Second thing is, are these type of remedies really effective? As I just mentioned a few minutes back, that these type of things have happened. People have analyzed, people have come to some decisions, but then are they really effective by the time they've come? Or is it just that, yes, the lawyers and others, some of them have lined up their pockets big time, but what else is the impact in terms of consumer welfare, really speaking? And the third thing is, in terms of this whole thing is, if you do these type of things, for example, there's a talk about ex ante regulation instead of doing a ex post. If you do these type of things, would this create a very heavy load for the regulators? Because the number of deals that happen is enormous. So for each and every deal, if you have to go to the regulator, there's going to be enormous caseload with them. And would that something may, on one hand, stop the air supply to the startups in one way? Another could be even in terms of chilling the innovation itself in that space. And just to give you a context, Google has acquired approximately 300 plus companies so far. There was a time about a decade back, Cisco was acquiring one company on an average per week. In 2010 and 2014, in both these calendar years, Google alone acquired 34 companies each. And if you see within India, we've got more than 1 lakh tech startups. And many of them, by the way, by design, their aspiration itself is, if you ask the founders, all that they say is that, okay, within few months, within few years, we want to be bought out. And remember, whether it is Apple, whether it's Microsoft, whether it's NVIDIA, whether it is Google, all of these were startups at some point of time. So that's the background. And we've got this fantastic panel here. I don't want to read their introductions the typical way. I just want to share one small bit about each of them. Mr. Dhanendra Kumar, the former chair of CCI, and of course, the former secretary of culture, executive director in World Bank, and many other roles he had had. But I had sort of the fortune of interacting with him since 1999, when he used to be additional secretary in telecom. And once on a Saturday, we had a meeting, and when she met him, he said, "Did you have any problem?" We said, "No." And immediately he called up the security. Said, "Why did you guys not check properly?" Okay. So that's one. Rajat, I know him again since 97, when he had just come back from World Bank and joined TRAI, and we were one of the early litigants in TRAI those days. But a lot of people don't realize TRA's Section 11 talks about competition very specifically. And if somebody just wants to understand the regulatory economics very, very well, there are two people here, I would say that they should read their stuff very, very well. One is the consultation paper and the tariff order, which was released on 9th March 1999, the telecom tariff order. But the consultation paper prior to that, which was written by Dr. Harshvardhan Singh, also has been associated with CSEP earlier, and of course Rajat with him. And of course, Dr. Rakesh Mohan's dissent on the national long distance, where again he had said that, okay, this is not a natural monopoly per se, but this is something that can happen elsewhere. And of course, then we've got people like Pradeep Mehta and others who also worked in this space a lot. We've got Archana. Archana has worked, of course, in different sectors. And but I remember our interaction in terms of USO1, also in Niti Aayog, and of course, subsequently, she was also with Google for some time. But more importantly, she is teaching a lot of youngsters in terms of economics and also public policy overall. And then we have got Manjushree, perhaps the youngest, not just amongst us on the panel, but also within the audience, one of the youngest, I would say, overall. And Manjushree, of course, has been working on competition policy a lot in Vidhi Center for Legal Studies, which is a think tank. They have done a lot of fantastic work over the years across different domains. So that's the background. And I just want to shut myself up now. And I would request all of you to sort of reflect on these type of issues for about 7 minutes each. And yes, we have Professor V. Sridhar. Sorry, Sridhar. Yeah. So Sridhar again has been teaching and researching. And by the way, perhaps the most prolific op-ed author in this country when it comes to digital, IT, telecom, etc. So more than 400 articles published over the more than 20 years. In fact, sometimes he gets like 2 or 3 articles published on a single day. So Sridhar is currently at IIIT Bangalore. And again, he has studied, written 3 books, but also has been doing a lot of interesting work. In fact, Sridhar, Rajat, and a few others were part of the Spectrum Committee chaired by Mr. Kumar, then Additional Secretary in Telecom, which was what led to the spectrum auction design, etc. at that point of time. So I would request all of you to sort of share your views for about 7 minutes each. Then I may have some short questions. And after that, we do want to have comments and questions from the audience, both who are here as well as many who have joined online. Thank you. So let me start with Mr. Dhanendra, and then we'll go.
Thank you, Deepak. Am I audible?
Yeah.
Let me first of all compliment him for putting together this very interesting event. The first time I have been to this building, and I never realized such a central place, beautiful building. And I hope that there would be more occasions to come here and meet now when Deepak is here. I started off by hearing some very interesting comment today when I heard this was that we are here, we exist because of Google, and we wouldn't have been here because of Google otherwise, and so on. So it struck me when I was thinking that we generally talk at home when our children sometimes Google Baba se pooch lete hain, Google Baba, and so on, all kinds of acronyms and so on. So it struck me that probably the best acronym would be that it's like a wife, that you have to live with her. You can't do anything, you can't control her. To be honest, you can't control her. In fact, when this judgment in District of Columbia came, and Justice Amit Mehta's judgment, somebody asked me, is he related to you, Pradeep? so I said, nobody can control Google. So yes, true. The topic related to big tech, and I heard some very interesting acronym also. That was GAMAM, which referred to Google, Apple, Microsoft, Amazon, Meta. So this GAMAM club is bigger than most other GDPs. And for India's, for example, it is about 2.5 or 2.6 times India's GDP, with about $11.2 trillion. And the revenue of Apple, for example, was about 383 billion last year, and Google, of course, similarly 237 only from the Google ads. So they are all huge. And the intersection of big tech and competition law is very fond of Google, and, and they have to intersect. Archana is here, and she has worked in CCI, and she knows that Google is a favorite whipping boy there, and so are many others. But there have been a number of cases in the CCI. In fact, many law firms exist, I think, because of Google and their appeals in the various courts, and they hire the most expensive lawyers in the country and around the globe to fight out, and sometimes win, sometimes remanded, but it goes on and on and on. So they control the digital markets and vast user data, and it is growing because there the same principle like the US presidential election holds that winner takes all, and it tilts in favor of the dominant undertaking. Google generates 77% of its revenue from Google Ads. And there are a number of features which were noticed, and these features were incorporated in our proposed digital competition bill, which again is a very hot topic of discussion. And this was mentioned in the flyer that you mentioned. There are several features. One is the tying and bundling, which came up. You gave the history, but for example, in Microsoft case in 2001, we all know what happened. Microsoft tied Internet Explorer to Windows, stifling competition. Netscape you referred to. So those things, and entering agreements, this is something which is rather pernicious, entering agreements to the detriment of consumers when, for example, according to the allegations, Google paid $26.3 billion to Apple and so on for maintaining its monopoly and not allowing others to use that. I mean, these are allegations. This was also referred in the judgment of Justice Mehta. Self-preferencing Google shopping case in EU 2021, when it was fined 2.42 billion for favoring its own shopping services over competitors, data privacy and exploitation, which was something again, which was mentioned and which formed the basis of a few elements in the digital competition bill. Let me spend a few minutes, although Deepak gave us the limitation of 7 minutes. I promise I won't exceed it. Digital competition bill, the bill aims at regulating systematically significant digital enterprises, SSDE, and the definition for SSDE has a number of features, and it is expected that many of the Indian biggies also, I mean, I'm naming not because I think that they would be covered, but it would be dependent on the features, the elements which define which are the SSDs. They could be, for example, Zomato, which is quite big, and the Swiggies and so on. Some of these could also be covered in that. In the definition, the financial threshold are defined that they should meet one of the following criterion in the past 3 years: INR 4,000 crore turnover, 30 billion global turnover dollars, and 16,000 INR crore gross merchandise value, and US dollar 75 billion global market capitalization. And this is one part. And then the user threshold, 1 crore end users and 10,000 business users. So we'll have to filter who all would be covered in this definition. Surprisingly, there is no feature which I noticed there that somebody could appeal. If I'm used as systematically this SSDE, that and I feel that I'm not included, then I couldn't find a provision for appeal, except that you would only write to the CCI. Then a number of obligations are set up on them. Self-reporting. Enterprises must notify the commission within 90 days of meeting the threshold, and splitting services to evade these threshold is strictly prohibited. And then the obligations which are imposed on them, they must operate fairly and transparently. Prohibitions on self-preferencing are anti-steering, some of the same things which have been noticed against them, against these GAFAMs and so on. Earlier we used to call them GAFAMs, now it's GAFAM. Using non-public data to compete and tying bundling unless integral to the service, and must allow third-party apps to let user change default settings. And there are very stiff penalties, up to 10% of the global turnover for violations, INR 1 lakh a day, up to 10 crore INR for non-compliance. And core digital services includes online service engines, social networking, video sharing platforms, communication services, operating systems, web browsers, cloud services, etc. Need for separate legislation. There are various conflicting views on this. Some people say that existing legislation, the competition law, can possibly take care of this with the special cell which has been created, but others say no, it is not, and they are becoming bigger and bigger and bigger every day. And we need to have an ex-ante regulations. Very difficult to say what is the best model for a country like India. The argument for is that tailored regulation, proactive measures, and reduced uncertainty. And against the arguments are overlap with the existing laws, enforcement challenges, stifles innovation, burden regulators. Some people say that CCI is already overburdened with limited staff and multitude, plethora of cases, and they are becoming a bit slow, according to some of the articles which I read. And if this also comes, then we'll have to really strengthen the capacity. Big tech is, again, as I said in the beginning, it has both benefits and also it is harming economy, as some people say, in several ways, but then we have to see what is the best way out. The benefits, for example, are that Google, as it was mentioned, we can't exist without Google. It's becoming part of our life in several ways. And they keep on coming up with several programs in between, like Internet Sathi program, which empowered over 28 million women across India. And they plan to invest $10 billion.
So can you come to some of?
Yeah. So many of these things. And then similarly, Flipkart, Apple, and so on. So they all have their own benefit, which they keep on advertising from time to time. On the digital bill, similarly, we have to see how to make it more suitable for Indian ethos and for Indian economy, and which a number of features have been brought out. In fact, I myself written extensively on this in my articles. But quite honestly, I feel that the best way would be if, for example, you can persuade. Now, Reliance and Disney, they have won their approval. If, for example, Reliance, which is India's biggest firm, they can come out with a browser which can really give a tough competition to Google. So it can't happen easily. I mean, it would take several years and would require billions of dollars investment. So best way would be like I mentioned, that it's like a wife. If you have another beautiful girl at home, then possibly they could all be more disciplined. So if we can have in India a very powerful browser, at least one, and we can see the results in Korea, for example. They came out with some laws which was called anti-Google laws and so on, or what China did. But in India, we don't have competitors. So we have to see what best we can do in controlling them. And until we are able to come out with a suitable model, it would only benefit the law firms. We'll keep on fighting in CCI and in appellate forums and so on. I think we also need to.
So can just.
Yeah, I'm just finishing up, just winding up. We also need to strengthen the capacity of CCI, both in terms of manpower and in terms of capacity building skills. So until there is a digital competition law, as has been mentioned repeatedly, the existing laws can be given a trial. How, for example, under Section 4 or wherever, or how can CCI judge technological behemoths to see whether they are violating the competition landscape, and which could be the various remedies which could be imposed on them. I mean, you can't really impose structural remedies in all the cases. There could be behavioral remedies and so on. So how best you can control them, which can only be possible if you have suitable skills developed in various divisions in the CCI, and maybe Archana is able to throw some more light on this. So with these words, once again, Deepak, I would thank you for giving me this opportunity and congratulate you on putting together this wonderful event. Thank you very much.
Thank you. Let me move on to Rajat. So, I mean, this whole thing about the Chicago rule in terms of the price being the major
Only
criteria for determining whether you have anti-competition or not, and now here we have something totally different. But looking at from that perspective, beyond even the Chicago whole thing, what are the other new developments that you're seeing in terms of the new tools that the regulators can and should be using for looking into these issues in the current scenario?
Thanks, Deepak. But before I begin answering your question, thanks, Lavish. Thanks, Rakesh, for inviting me. This is a great panel, a wonderful topic, something that I've been working on for several years, as Deepak mentioned. I'm unfortunately not going to be able to pinpoint the exact dates and days that Deepak was able to do. He has a knack for this, but I don't. I forget dates. So in what I say, the sequencing might not be completely accurate. But let me put out my sort of cut to the chase and give you my sort of views, and I'll tell you why they've changed over the years. I don't think we need a new regulator, a new sort of CCI. I think we can do with the same. As Dhanendra ji said, probably we need to strengthen it. When we probably need a better law, a more encompassing law, and I think we need ex-ante regulation. I've changed my views. Like Keynes used to say, if you look at new data, what do you do? I change my views. What do you do? You know, I was sort of trained in a tradition which was not exactly Chicago school, because I was Maryland, but you know, the focus was really markets work and market failure. While it existed and market failure has never not existed. It continues to exist. The tools of correcting for that market failure were worse than the market itself, and therefore Google or Amazon, or as Deepak was mentioning, from an unlikely source, you'll have competition emerge to topple the existing monopoly. So the Schumpeterian competition will begin to prevail, and therefore all will be fine in a few years. Has the digital world, I don't think monopolists will change. And this is a view that I have developed. I've changed my views. I think markets fail even more than I thought they did, and they don't self-correct themselves. So we need sort of intervention, but we need better regulation is an art rather than a science, and that art needs to be developed carefully. So those are my views, and I will try and sort of justify what I'm saying. Monopolists will always engage in monopoly behavior. You show me a benign monopolist anywhere in the world, you know, starting from Standard Oil to Rockefeller Standard Oil to today, whether domestic or outside, I haven't seen a monopolist that hasn't chosen to abuse or at least profit more than it should. I don't know how you define these things, but to profit from its monopoly power, from seeking rents to its monopoly, it will continue to do that. The tools of doing that also haven't changed really. The tools continue to be the same. Whether it's predation, whether it's vertical integration, whether it's exclusionary conduct, whether it's locking in the customer, these tools have remained absolutely the same. From Standard Oil to Amazon to Google, I mean, you see them, Deepak mentioned, and Dhanendra ji mentioned time, bundling, increasing your switching costs. There are sort of hundreds of examples in markets where you've seen the exercise of this conduct, and whether you think that this is abusive or not, it's a different story, but you've seen the exercise of this conduct. And you had the famous paper of, so Bork's thesis, which the Chicago school endorsed, and from the Chicago school, which Deepak was talking about, is price the only variable? And obviously at that time, the received wisdom was prices is the only variable. So if consumers are benefiting and consumer welfare is being enhanced by low prices, then why do you need to get in? Because markets will correct themselves. Another Amazon will come up, or another chat AI GPT will come along the way. So governments will make it worse, so just lay off. That was the sort of received wisdom. And I think that's flawed for various reasons, I think. And one of the reasons is that, one, it's no monopoly is going to resist the temptation of exploiting its position in the market. And two, I mean, you are making profits by even low pricing, as Leena Khan told us, that the low prices were actually still allowing Amazon to get huge amounts of investments from potential investors. So while they were losing money, they were afloat. And today, it's one of the most profitable companies in the world. Now, should we have intervened at that time? It's like asking the question, should in 2016, TRAI have intervened when Jio reduced the prices by data prices from what, 225? Deepak's good with numbers. And 16th September 2016.
That's right.
Yes, yes. So Jio brought down the prices by 100 and some percent from 200 to 10 rupees per GB. And should it have intervened? Rahul Kundad, on record, the former TRAI chairman, not the then TRAI chairman, the former TRAI chairman wrote that TRAI should have intervened at that time. But the current TRAI let it go, saying that it was not predatory because predation is not an attribute of an entrant which has no market share. So Jio had no market share, it had just come in, and therefore it couldn't be exercising. Now, I think those ideas need to be challenged in this scenario, precisely because, as you will read about Amazon, what is Amazon? It's not a bookseller anymore. It's everything. It's an auction house. It makes films. It produces films. It does everything. It's a credit. It provides credit. It's a payments gateway. It does everything. So it's a conglomerate. It's what economists and the EU has called a digital conglomerate. And therefore, I think the tools need to be changed. The tools need to be revised. It's not clear how the tools would be revised, but we need, apart from quantitative indices of determining what is market power, I think we need a lot of qualitative, honest qualitative analysis in this sector. This is something what we call the process of allowing competition to prevail in the market, the process of facilitating competition. Because after all, what does the regulator do? The regulator facilitates competition. And to be able to facilitate that competition, the processes of competition need to go beyond price. They need to go to innovation, as we've just said, and they also need to go to quality. And I just wrote an article in an op-ed. I'm not as prolific as Sridhar, but once in a month or so. And I said that in telecom, I think while prices have come down, so has quality. So you've got competition has, while it's been able to reduce price and now prices have gone up, I think competition has also been responsible for the race to the bottom in some sense, because you've compromised on quality. And you remember when aviation industry in the US, when competition emerged, there is some evidence to suggest that safety was compromised and the number of accidents in the US airline industry actually increased when there was deregulation. I mean, there's some evidence to suggest that that happened, although I'm not sort of completely sure of whether there's a causation or merely a correlation. So we do need ex-ante regulation. I'm not sure what the tools are going to be. One has to look at the tools. I mean, Dhanendra has mentioned some of the tools, but I think a lot more of qualitative analysis. And I'll conclude, and I'm happy to answer questions. I want to conclude by referring to a point that Dhanendra made, and it's an important point, which is developing a source of competition for, let's say, Google or Amazon or whoever. So how would you get that source of competition? One way to get that source of competition is wait for the market. Chicago said, it's like, waiting for Godot. It'll never happen. It could have happened then. It's unlikely to happen now because they've just cornered the market. There's kill zone, there's buying off innovation, there's killing companies. Of course, companies want to be bought, but they also kill companies. So, I mean, the market while at one level the market works better, but at another level, I think the market is also compromised hugely. So if you recall Airbus and Boeing, that's the example I want to give you. There are some WTO cases on this, those of you are interested would, and this is long back, this is in the 80s. Boeing would not have emerged on its own. Boeing is a product of huge subsidies from 6 or 7 European governments, huge $1 billion worth of subsidies.
Airbus.
So Airbus,
Airbus,
right?
yeah.
Yes, sorry, Airbus. I'm sorry.
Yes.
And Boeing was obviously a dominant monopoly in that space, especially in the wide-bodied aircraft. In narrow-bodied, you had some Canadian and Brazilian manufacturers, but in wide-bodied, it was all Boeing. So they actually invested in Airbus. And I remember Boeing filed a case in the WTO. And the EU commissioner at that point, I still remember the statement in the WTO. They said quality is bad, you're subsidizing, this is anti-WTO. And all. The EU commissioner said, Airbus would have to fly backwards for us not to subsidize it. I mean, that was the extent of subsidy because it was unlikely that competition for Boeing would emerge on its own through the market. And I think in this, I don't know whether that would work or whatever, but try and incentivize the creation of competition from an unlikely source so that you're able to provide some countervailing power because, CCI and competition authorities can do only so much. I mean, there are all kinds of problems, the time, the capacity, legal, if I were to relive my life, I'd become a telecom lawyer. I'd be laughing all the way to the bank, right? So the point is that the market will do it on its own, it won't, and therefore the markets need to be supported by the government. The regulator also, it will be sort of insufficient to control the kind of monopolies that we see emerging in today's marketplace.
Thanks, Rajat.
Thank
So,
you.
I mean, talking about EU, a couple of things come to mind. One is, of course, under the EU's Digital Markets Act, they have already notified 6 companies, including one of them, which is not operational in India now, called ByteDance. They used to run TikTok. So, including them, 6 companies have already been notified across 22, what they call as a particular type of services. If you're doing in that, then those things have been done. And just last week, when Ruchir Sharma was talking to Nandan in Bangalore, he mentioned that EU is the Silicon Valley of regulation. So that's another aspect of EU. So let me return to Archana now. So Archana, if you see in this whole space, what is happening is, yes, there's this whole thing about killer acquisition. There's a talk about that. Then people are also talking about how, let's say, a company X has acquired another company Y or Z or whatever. And a few years later, if the regulators do come to some decision or where they believe that it should be now separated again. So basically, some people say that's something more like a unscrambling an omelette. Okay, so how do you do that type of thing? And what are the implications, if at all, somebody were to venture into that type of path, looking at from, I mean, not just from your stint at CCI, but also more holistically in terms of your experience overall. For example, I mean, the very fact that we had USO fund, because nobody would go to those areas, not even BSNL for that matter, which was a common company, and because it was just totally unviable for them.
Thank you, Deepak. Thank you for inviting me. It's a pleasure to be here. I don't know if you can hear me because these kind of mics are not very kind to women in saris. Okay. I have.
I can hear you clearly.
All right, perfect. Thank you. So just commenting on some of the wonderful, conversations that we've heard before I spoke, starting with Mr. Dhanendra Kumar, and this is on a lighter note. I think there's a lot of younger generation here which would agree that, I don't know about wives, but husbands can be controlled, sir. And one of the most important things that, apart from husbands, I think the most dear thing to most people these days is their pet. And, one of the things that you learn about controlling a dog or training a dog is it's not just good for the owner, it's very good for the dog to be controlled and to be trained. So I think I'll start on that note. It's also very interesting coming to what, Mr. Maheshwari was saying, that it took an Indian origin judge and it took a lady who's of Pakistani origin to prove to you that behavior that has been continuing for decades is anti-competitive in the US. I mean, not for the EU, which is like, like you said, the Silicon Valley of
and in a company where the CEO is also of Indian origin.
Correct. But it took those people to tell you that the sun rises in the east because, yeah, they came from the east, right? So I don't think India should wait for somebody to tell you. The Competition Commission, like every other regulator, competition regulator across the world, has been dealing with antitrust cases, mergers and acquisitions, dealing with digital markets for a very long time. And you don't need it all to be in the CCI. When we worked in the CCI, I was one of the people who started with the mergers and acquisitions and, the more important cases. We didn't invent the wheel. We learned from the West. We learned from the best practices of the West. And we didn't feel ashamed because of that. If somebody else has come up with the regulation before us, that's fine. Because the way big tech operates, it's the same across the world. And the more lax your regulations are, the worse your consumers will suffer, the worse your local businesses will suffer. So why do you need to wait for anybody else? I think the wheel has been invented. It is for us to know how to adapt the wheel to our requirements. And I think that anti-competitive behavior has been proven again and again and again, whether it's by the European Union, finally by the United States, whether it is in India. Now it is the time to tell these people that, we don't need to prove to you. We don't need to get tied up in knots by whether this is the correct definition of the market or whether this is the correct procedure or whether something went wrong with a meeting in the Competition Commission of India where somebody got up and went to the loo or something like that. No, we are now clear that these behaviors harm consumers. And just to take you away from competition for a minute, we're all aware of content regulation, right? We're all aware of the problems with privacy and data protection. We're aware of youth today being highly affected by the fact that they are so much addicted to social media. Their entire self-perception is created based on social media. You're aware that social media affects the results of elections and it can be influenced. You are in the age of AI today, and unfortunately, even artificial intelligence is primarily controlled by the same handful of companies across the globe. Even if you have a new company, it will still be a major monopolist, right? So once you have all these things which have played out not for a few years, but over decades, it is time for ex-ante regulation. Now, the beauty of the Digital Competition Bill, I don't know if everybody has read it, it's very simple. It's just laying out some 6 or 7 things. It's telling you, operate in a fair and transparent manner. I'm sure that is not objectionable. It's quite quite a fair thing to ask a business to operate in a fair and transparent manner with consumers as well as your competitors. That's number 1. Number 2, if you are a platform, don't self-preference, which means like our FDI regulation in 2018, which essentially targeted a major global e-commerce platform, which said that you please operate on a platform model, don't be an inventory model, in the sense, don't promote your own products. And what was the problem? Because this big e-commerce platform was essentially taking the data of vendors and of course consumers. You and I are nothing but one digital identity which is traded again and again on markets. But let's leave that aside. You take the vendor's data, you find this product is popular on the market, and then you replicate that product and then you promote that product in the search ranking, right? So to prevent that kind of thing, the FDI rule set, and it's already ex-ante regulation which existed in 2018, and we are in 2024 right now. Said don't self-preference, right? Don't use your vendor's data to promote your own business. These are all the things that are just being captured in a very simple layman's language in a digital competition bill, right? What else is there? It says, allow data portability. Would you like your music from Amazon Music to be portable to Apple Music? Why should, if you're so good, if your product is so good that people want it, which is the argument which most big tech make to competition regulators across the world, then why do you need to do all these underhand things to, make sure that you are the default option on a mobile phone or data cannot be ported? Why must I be held ransom on your platform just by my data? Why should I be held hostage by you, right? If you are so confident about how good your product is, you shouldn't have to, deploy such underhand means to make progress. So I think that argument, in my view, I mean, I'm happy to answer any questions. In my view, that argument has been settled. To me, the bigger point is we need ex-ante regulation, but how do we go about it? Okay, so the bigger point for me is who has the capacity? It really makes me laugh when that is given as a reason why you shouldn't have ex-ante regulation. Or CCI will be overburdened, or the regulator doesn't have capacity. For one thing, maybe you don't need to have it in CCI. You could have a sector regulator to deal with digital markets, right? Because there are many other aspects of digital markets that need to be regulated. And if it is to be within CCI, what stops CCI from improving its manpower strength or its capacities? Capacities are built over time. In this panel, you have people who've existed in the telecom space for, including Mr. Sridhar, for decades, right? We have seen capacities of the telecom regulator build up from landline to mobile to OTTs and onwards. Capacities get built up. There is no problem. Why should we not be able to build up a capacity? Why should our Indian businesses, and then I don't agree with the cosseting. Why do we need to create a pampered space for an Indian business to grow? I don't agree. I think Indian businesses you need to create a market which is pro-competition and pro-innovation, but Indian businesses will grow provided you don't have anti-competitive behavior preventing them from growing. So you don't need subsidies, but you need a market which is a fair market, which allows competition. And Indian businesses should grow up with the best practices, because nowhere around the world is there going to be any tolerance for exploitative behavior aimed at consumers or competitors, because that scene has changed, that ship has sailed. It's not going to happen. So it's better that Indian businesses also understand that this kind of anti-competitive behavior is not going to be tolerated. So that is the other point. And another thing that really makes me laugh is, when you say, why do you want to ape the West? Why do you want to follow legislation which has been designed by the European Union? The European Union doesn't care for innovation. I don't agree. As I already mentioned, you use the best practices across the world. You don't reinvent wheels. You decide how to use regulation. So for me, that issue is a settled issue, and it is more about how do you now having defined what is anti-competitive behavior and that, these are forbidden. Now the question is, how do you fine tune the regulation? And for that, yes, you can go slow, you can build up capacities, you can fine tune to Indian requirements. So as far as I'm concerned, that is where my position lies, and I'm going to stop because I'm going to stick to those 7 minutes, but I'm happy to answer any questions. Thank you.
Thanks, Archana. And let me move over to Sridhar now. Sridhar, can you unmute yourself?
Yes. I'm
Okay,
here.
thanks. So Sridhar, if you look at this whole thing around competition now, what are the things that you're seeing, especially from, let's say, not just Europe or US, which of course are cited pretty often, but many other markets, so whether it could be Singapore, it could be Japan, it could be Korea, etc. For example, Japan, just this summer, they introduced a new law which addresses competition only in the mobile app store space. So it's a very specific, narrow sort of legislation in that sense. So what is your take on these type of possibilities that, okay, instead of trying to do everything in one go, just look at what are the biggest problems that we are facing and take some very specific targeted action around that.
Yeah. So, definitely, as you have pointed out, the regulators in EU, FTC, and CCI have become really prominent, very active, especially the Digital Markets Act and Digital Services Act, put a lot of caps on how to contain, anti-competitive behavior. So, but there are some situations, for example, South Korea. I mean, if you take, for example, the proposed and it's yet to be enacted Netflix law, which basically provides some ammunition for telecom companies to extract a part of the revenue of the content providers in order to build up capacity because the content providers take up a lot of capacity or bandwidth, and the telecom regulators are heavily regulated, whereas the content providers are not regulated. And therefore, there is no reason for the content regulators to pay a proportionate fee in terms of how much traffic they put onto the telecom network to the telecom operator. So this has been so they have not it has not yet been announced, but there has been a case which is going on as to why, for example, the content providers have to sort of bear the burden of network infrastructure building along with the telecom operators who are regulated anyway. So these are some of the things which are going on. But, going back to the capacity, I want to point out something, Deepak. So we have always been saying that, the EU, there are two things which will make regulation on competition work. One is heavy penalty. I mean, EU has been fining, all these companies which are exhibiting competitive behavior quite a bit, and therefore the cases are going up, and the anti-competitive behavior has been coming down to some extent, thanks to the DMA and EU GDPR and so on. Now, the other question is, I mean, are the penalties so cheap that they can get away with it? They're not, because, for example, the DMA levies up to 10% of the annual global turnover and so on. So it is very high. The question is auditing, right? So, for example, especially with respect to India, this question has come up again and again. The regulators, do they have enough capacity to audit? Only if the auditing is very good and the penalties are severe, that these kind of anti-competitive behavior will come down, right? That's what we have been noticing all over the world. So, departing from the question that you asked, I mean, from India's point of view, can we build the regulator capacity in order to address all these concerns, or do we look at something which is entirely different? I'm going to propose one thing: whistleblowing, right? So, for example, the first time in which the in the US, including Jeffrey Hunter, who is the godfather of AI, has proposed giving protection to whistleblowing within the companies so that they can flag certain anti-competitive behavior, right? So that may be one of the ways in which where we have insufficient capacity for the regulators. Can we promote, for example, things like whistleblowing? I mean, it is especially important when we move towards AI, AI safety rules and things like that, right? So that is one thing that I want the panel to consider. The second one is there are a lot of new kids on the block, right? So, for example, apart from the big techs, Google, Amazon, and so on, there are cases which are coming up from NVIDIA, right? Which is in the France just now, it has been raised that NVIDIA is going to become a graphic card monopoly. OpenAI, there are a lot of cases which are coming up on intellectual property, on AI rules and safety and explainability, and so on. So cloud services have recently been in the EU radar, especially in Germany, after the cloud strike incident which has happened. So there are a lot of new kids which will be on the block, apart from the large, three or four big techs that we have been envisioning so far. The last thing that I want to spend some time is, can we break this anti-competitive behavior? Now, India has done some reasonable initiatives on building open networks. For example, the account aggregator model, or the open network for digital commerce, UPI. All these are interoperable framework, and these have promoted, for example, competition, especially in payment services, in digital commerce, and so on. Now, these are still evolving. India has done a wonderful job in creating the benchmark for these digital open infrastructure. But will it break the monopoly is a big question mark, right? So, for example, OpenAI, everyone thought that OpenAI, because it is open, it's going to be interoperable. For example, I previously said, I mean, if it is interoperable, the network effect, cross-site network effect will increase, and therefore, why not interoperate, right? So, but however, over a period of time, we have seen OpenAI to become a monopoly, right? So, these are some questions that we want to address for the future. Especially whether the open networks, if at all they have to be deployed, who will deploy it, and whether we can force interoperable rules in order to break the monopoly in a situation, and so on. So I've not really answered your question regarding regulations around the world, but I have sort of posed some interesting points for the panel to discuss on new things. Deepak?
So, I mean, let's look at these things, Manjushree, for example. We have Competition Act.
Yeah.
We have, of course, intellectual property right. I mean, different legislations related to that, which also, of course, impinge when it comes to standards, things like that. By the way, we already have a Whistleblower Protection Act, okay, in India. Now, what Sridhar is saying is in terms of let's say, using a whistleblower sort of protection in the competition space very specifically. Okay. So what are your thoughts around this type of thing, apart from, of course, the general take on the questions that we discussed earlier?
Absolutely. First of all, thank you, sir, for having me here. And it's a stellar panel. It's great to be part of a discussion that is really trying to, shape the narrative around what sort of an ex-ante regulation is required, if at all. Professor Sridhar, I must confess, I've never really thought about a whistleblower until you really brought it up just now. So my answer to that might be very shoddy. So I think I'll stick to what my strengths are, which is largely the draft digital competition bill. So full disclosure, Vidhi was part of the committee meetings with the committee on digital competition law, and we assisted the MCA in sort of coming out with the report and the bill. But now that it's in the public domain, I think it's really on all of us to make it better, because there is one part of the question, as I think that everybody sort of touched upon, in that I think we're a little past that question of whether we need an ex-ante law or not at the moment. I think there is some sort of in principle agreement, at least, that digital markets work very, very differently from how traditional markets work. And the kind of enforcement that is envisaged in Section 4, otherwise in the Competition Act, may not really, suit digital markets. But having said that, it is a completely different question as to whether the current version of the draft DCB is what we want to have as an ex-ante law for this country. And I'd like to take a moment to sort of frame that debate using two very important questions. First, it is important to ask the question, who are we regulating, as it is to ask the question, who else is inadvertently getting covered in ex-ante regulation? And my fear, largely because, again, the draft DCB is modeled pretty much around the DMA, that we might inadvertently have a lot of our own startups, not being able to, use the advantage of a deregulated environment to reach the kind of level that where they would actually be effective competition to a Google or to an Amazon or to a Facebook. So really, the question that I wanted to pose is, we are looking at maybe 6 entities in the DMA that are getting caught on the gatekeeper threshold, but a simple sort of an analysis of the thresholds that we have under the draft DCB puts that number, even a very, very conservative estimate, puts that number around a 25. So the question is, what is the error cost that we're willing to bear to be able to regulate the big tech better? Now, that is an entirely different question from whether big tech needs enhanced regulation. I think there is principal clarity, but the question is, for that, what is it that we're willing to give up? That's one part of what I'd like to speak about. Second, I think the debate around ex-ante regulation has largely framed the trade-off as one of under-regulation versus slightly increased over-regulation. But I think in India, given the state capacity concerns that everybody has touched upon this table, I think we need to really ask ourselves, what is the, this is really a debate about under-regulation versus imprecisely defined over-regulation in a space that is in an ecosystem like the digital ecosystem. By the time where we have regulations on each of the core digital services that are mentioned in the draft DCB, it might be a few years, and the market might have really changed by the time we see the enforcement of a bill like this. That is part two. And the third point that I'd like to sort of bring up here is, I am not sure if we can fix how we look at competition regulation without really fixing our appellate system in terms of what happens to a case once it leaves the CCI's hands. The CCI is one of a kind body really in India, and the NCLAT unfortunately hears appeals not only from the CCI but also the Companies Act and the IBBI. So the disposal of cases at the NCLAT level and the number of cases that finally reached the Supreme Court that are still waiting to be disposed of clearly reflects in the way penalties, for instance, are recovered by the CCI. So are we willing to open a floodgate of litigation here? Because I don't think our courts are equipped to really handle that. There are far more important things that our courts are dealing with at this point in time, and I'm not sure if we want to overburden them with cases from digital competition. And the reason I say this is because it is these behemoths that do have the wherewithal to make this bill a lawyer's field day, to take it to courts and litigate it to no extent, right? And really, the ones that might have to suffer are the ones that cannot really put up with the compliance cost that something like the draft digital competition bill might impose. So to sort of keep it short, I think we are at a great juncture where we all have the responsibility to shape the debate around ex ante versus ex post. I really hope that more informed discussions like this take place in a way where we can reach a consensus on what a model for ex ante regulation for Indian reality should look like. Because one of the things that worries me really is that I think, yes, I know a consumer welfare standard may not work very well in digital markets, but then what is really our touchstone? I'd like for us to have some debates around what is the vision of competition that we are comfortable in India, and that may be very different from EU's political reality or the US's political reality. So how we do it, Professor Sridhar, I think also had a few ideas taking from Mr. Maheshwari's point of about, maybe we could look at sectoral regulators, amping up how sectoral regulators and, say CCI interact for the purpose of, doing competition in a very sector specific manner. TRI is one example where, competition vis-a-vis the telecom industry is something the TRI looks up. Can we, have something similar in that org instead of, thinking about putting all of this on the CCI shoulders? Can we think about also proportionately strengthening other regulators in a way where they act complementary to the CCI to ensure that, competition is preserved? Because when we're looking at, big tech as a whole, I think we're looking at an ecosystem at large, and there are many tools in our kitty to ensure that this ecosystem is as fair and as contestable as possible. And I think competition from a systems angle is just one of those tools, and we really need to contextualize that tools in relation to what other regulators and what our regulatory landscape otherwise looks like.
Thank you, Manjushree. So, I mean, you just mentioned about NCLAT. Now,
Yeah.
look, NCLAT still deals with these type of issues. You look at another regulator in the digital space, by the way, called TDSAT.
Right.
Now, TDSAT, most of the people don't realize TDSAT is today a regulator not just for telecom or broadcasting, but also for cyber under IT Act. Also, by the way, if you have a dispute, let's say, between GMR and Airport Authority of India, because again, that's the same regulator there. And under the DPA, all the appeals from DPBI will also go there.
Yeah.
So that's another thing which is going to happen in terms of the state capacity, if you see. Now, the other thing relevant here is this. I think what happens is oftentimes when people get inspired, as Archana was mentioning, in terms of, let's say, the legislative text or regulatory text from elsewhere, is that the text is adopted, but the context is often lost.
Yeah.
And I think that's where we do need some more thought and attention in terms of getting the context also. Now, in the interest of time, I would, instead of asking the second round myself from the panelists, I would rather open up now for some brief questions. And my request would be to just introduce yourself briefly, and if you can be have sharp, quick questions, that would be best. And in case there are any questions online also, we can leave those also in between. And then during that course, of course, the panelists will have an opportunity to sort of react that as well. Yeah. 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 And Karthik.
Yeah. Good evening.
Yeah.
I'm Rakesh Maheshwari and had been part of Ministry of Electronics and IT till about a year back. I have few questions, and the first.
Can you limit to one question?
Yeah.
My request.
Okay.
Yeah.
Okay. So if there is a limit, then I'll just go through the App Store kind of scenario wherein it has been stated that any kind of app should be allowed from any source. Actually, going by the regulation, sometimes government also has to block. And if you need to block, you can only reach out to the limited number of players. So that's one limitation which will be there. And second issue which it poses is the problem of the security. That if you have certain verified, well-defined, responsible maybe stores, you can always control them, regulate them. But if it is just left to completely open, actually it will lead to huge number of vulnerabilities in the mobile, at least in the mobile ecosystem, and therefore will pose even a national level security.
Okay. Thank you. We'll collect maybe 2 or 3. Yeah. Can you please pass on the mic over there, Lavish, and then, yeah.
Yeah.
Karthik. Yeah.
Hi, thank you for the wonderful discussion. This is an extension to what Manjushree was also talking. So the question I have is it in the interest of developing countries to be strongly ex ante towards big tech, given that CCI has been very hesitant in being ex ante in its approach in the past as well, especially in terms of regulating even disruptive behavior from domestic companies, like it was in the Geo case, or we saw even in the automobile industries. So there has been difference in approach that you see globally to similar issues versus the Indian approach in the Competition Commission. So what would you think in terms of India's approach to big?
Yeah.
Two questions, and it's more about the ambit of the Competition Commission. Just read that this Geo Viacom Disney merger has been passed. Didn't read anything about any questions, any concerns, any thoughts that must have been raised internally in CCI. I don't know. Have no information on that. I'm sure it will be released in the near future. But the question is it also not the job of CCI to keep the public informed of the range of issues that they are normally considering? You may not have a perfect answer, but I don't see any of that. And that's really, really worrisome, especially in this context where something could probably be half the market, right? Second, when will and who will say that the public sector needs to be a part of CCI ambit? NPCI, UPI are just completely out of it, it seems, right? But I don't hear any conversation by anyone talking about this. So just a question of, aren't these thoughts raised internally in CCI or amongst other thinkers?
And is on the side, anybody, any question?
They're all from the left.
All right. Or looking from their side on the right. Okay, all right. So let me request panelists here to sort of respond on this. So maybe Mr. Dhanendra Kumar, if you could sort of react to this, that should CCI be more sort of be more transparent in terms of what type of cases that it is actually dealing, not just in terms of listing the cases, which of course is in the public domain, but also the real issues therein and what is happening, and more importantly, what can and should happen in future, and also in terms of public sector. So what type of public sector monopolistic behavior, in some cases it could be just because of the history, but in some cases it could actually be quasi-regulatory sort of emergence. For example, NPCI has said that, okay, you can't have more than 30% share of their sort of partners in a way who are using UPI or who are implementing UPI, etc.
My response to both these points would be yes. CCI should be more forthcoming, should be more transparent. People have a right to know what's going on and how it is going to be corrected in case there are any issues later on. Not only this, but also in terms of, I know that they must have been, in this particular case which you mentioned, there must have been commitments, and those commitments would have been given voluntarily or after discussion. And then the parties, I mean, having given commitments, would possibly forget after some time, unless the CCI चाबुक चलाएं उनको और फिर देखें कि भाई ये ठीक कर रहे हैं नहीं कर रहे हैं. This must happen. It has not happened in the past in several cases. So there have to be absolute control on what is happening. It could happen through, let's say, one of these big four, Pricewaterhouse or whatever, or one of these institutions who should possibly keep an eye on what is going on as far as these commitments are concerned. So,
and on the public sector side?
Public sector also, I would say the same thing. And in CCI, for example, CCI has imposed very heavy fines on Coal India and things like this. In fact, talking of Coal India, I think a lot of work which needs to be done. And it's a monopoly which is not doing exactly the kind of service which it can or it should do. But since I got this opportunity to speak, I'll take 1 more minute out of whatever time you give me. I'm suddenly tempted to mention about a personal anecdote. I was in telecom, as you mentioned. I was additional secretary in telecom from 98 to 2002. And during those days, I remember every Friday, a former cabinet secretary, I can mention Mr. PK Kaul, he would call me from Noida. Dhanendra, he was my boss earlier. Dhanendra, can you get my telephone repaired? So I said, sure, sir, this is my job. So I would get it repaired and check up in the evening. It's okay, sir. Yes, it's okay. 3, 4 Fridays it happened. After that, he never called me. So I thought things have. Then once I met him at a party in Noida and I asked him, sir, now everything is okay. Yes, everything is okay. I didn't know the system earlier. After my retirement, I came and said, now I know the system. So I said, sir, what do you mean by what is the system? So people in the lane, everybody used to pay the lineman. And so I was also
Keeping the lineman happy.
so I said, sir, is it true? And as former cabinet secretary has to pay money to keep his lines in order, if that is the state of things, then it's a shame for us. And can I raise it in the next telecom commission meeting? I said, by all means, I'll send you this thing in writing, and that letter is still with me. He sent it in writing that he is paying this thing and this is what happened and all that. Now, what could not be happened, and nothing happened, by the way, after the telecom commission meeting. All the members, telecom and chief engineers and so on were pulled up. Nothing happened. Now, what could not happen at that time happened after the competition, when the mobile telephony and the landline telephony open competition, everybody came and now they. So the point I'm trying to make in this debate regarding big tech and controlling them, that's why it may have sounded a little in lighter vein. I think the ultimate best solution would be when we have a competition. And that's why I mentioned about Reliance or whoever comes, or Adani or whatever. If there is a competition, if we have a browser of a few browsers of our own, and there is a tough competition given to these people, Googles and Amazons and all these people, things would improve. Okay. And the same thing is happening now in the airline sector. We have a monopoly of Indigo, and you see what is happening. They are raising prices at their own.
Can just move on.
Yeah.
So Archana, can you take up this thing on the App Store, for example, if you have this type of freedom and the type of implications that Rakesh just mentioned, what are the solutions and what are the guardrails, if at all, that type of thing has to be more open and allowed that way?
Yeah. So basically what Mr. Maheshwari is referring to is the fact that with things like the DMA or the Digital Competition Bill, the idea is to say that you are allowing side loading. So normally what happens is today, if you try to download an application, say from the open web, you will suddenly be bombarded with lots of warnings that, are you sure you want to download this app? There are security concerns, etc. So these are actually deterrents. They're basically trying to discourage you from downloading apps from elsewhere. And of course, some of it is required because, some apps are not safe, right? So this is, it is a problem. It is something that is faced by the government. But then, Mr. Maheshwari, you and I both know that is not, the fact that you have only 2 app stores in the market has not solved a lot of problems. The government still faces a lot of problems. For example, we had this major loan app scam where people lost their lives. Thousands of people lost their lives because they got trapped into taking loans from unscrupulous, loan companies, which were not actually regulated at all by the financial regulator. And I think the problem was solved when the tech platforms actually asked the regulator, the financial regulator, to come up with some regulations to solve the problem. So it was really not entirely on the technology, it was more to do with the financial markets, right? So these problems will come up and they will get solved. And the fact that you had only 2 app stores with all their security concerns and their 30% fees did not save those people from dying, right? So I don't think and also, if you read the DMA carefully, you will see that when they say that you allow side loading or you allow app stores, they are also subject to safety standards and security standards and caveats. It's not an open market. Anything that you do in the digital space, which impacts lives, which in fact the digital space does impact lives, has to be subject to regulations and standards. So the thing is, I think most people don't understand that competition exists for the benefit of the economy and consumers. It is not a subject matter of debate. It is not something that in my economy, should I have competition, or, is it okay only for the West? Not. Competition is essential for an economy like ours to grow. I think, and there's another point that I would like to address, because I know it's a different question, but in our country, we have a lot of youth. We have a very young population who are obviously going to be on the internet, but many people are not digitally skilled. We have elderly people. We have first-time users from rural India. By the way, does anybody know what is the percentage of rural Indians who have access to broadband today? Sorry, that's a professor in makeup. No, you don't know. It is less than 50%. So you have 50% of your population still to connect to the broadband. And when they do connect, who's going to safeguard their welfare? At present, with the lack of competition, there are very unscrupulous practices that are being followed. In our country, we need more regulation, not less. We need safety by design and by default, and we need competition by design and by default.
Thanks, Archana. So, Manjushree, when we're looking at these type of things, like Karthik was just asking, in terms of so what's your reaction to that type of proposition in terms of how good the laws are in our country?
That is such a
Loaded
broad
question.
and but very open-ended, but also a very specific question, I suppose, in this regard. So we'll just contextualize that a little bit, right? I think I was reading this somewhere the other day in terms of how the road to hell is paved with great intentions, right? Yes. So I'm not doubting for a second that there is concentration in digital markets that is unlike what we've seen in other markets. So there are reasons for us to think outside the box when it comes to digital markets regulation. But where I would perhaps disagree from from some of the esteemed guests on this panel, guests on this panel, is perhaps not everything that we're pointing out here is perhaps a competition concern and not necessarily something that the CCI should care about really. So one such thing, and that ties into what really competition is. Competition is accountability to the market. Regulation is accountability to the government. Now, there are places perhaps where we want both. There are places where one might work better than the other. There are places where one is sufficient and the other is not needed. And this is a very subject, it's a very case-by-case basis analysis. And I think specific to what Karthik was saying in terms of a developing economy, I completely agree that we shouldn't, just because we're a developing economy, that we shouldn't aspire to be competitive. Anything that's more reason as to why we need to be competitive, in that it is almost a given that in most markets, innovation flourishes when the market is competitive. But what perhaps makes me qualify the statement a little is what Lavnish brought up in terms of UPI, right? There are some places where we've realized that some markets, natural monopolies perhaps, that they may tend to work at least for a short time better if they are, concentrated in some fashion. UPI is one such example, in that it may not be a private-owned sort of an infrastructure. Maybe that's what really sets it apart. NPCI's governance is another different issue altogether, because it has a bunch of privately owned banks that are shareholders with an RBI director,
including a couple of foreign banks who were co-founders.
Exactly. So you're one way avoiding accountability to the market because you're a not-for-profit entity, and you're avoiding accountability to the government because there is an RBI nominee person that sits there. So, perhaps my opinion on whether there are some core infrastructural facilities when it comes to digital markets may function better if at all it acts somewhere as a monopoly. I think in my head, at least, the jury is still out on that. I don't think I've completely formulated an opinion fully on that. But coming back to what Karthik was saying, right? I think developing economies, the idea is not that we shouldn't be competitive. I think there is a right dose of competition that is great for most economies in a way where innovation will flourish. But there is also a flip side of an overdose of competition. I think something that we were all, initially talking about, there is also a bunch of US cases that talk about how, the quality of meat suddenly went down when we're looking at a couple of, there was horse meat served instead of, beef when competition was so high that the pressures on keeping prices were so high that they had to compromise in the standard of meat that was, issued, or the famous, US admissions case that was going on in terms of antitrust, in terms of a number of universities colluding with one another to match, scholarship offers to different students, because, if you're really talking to each other, if someone's offering 20,000, then I will also only offer $20,000 as a scholarship.
Okay.
So in such a case, this is a collusion that is, problematic. But I don't think the fact that we're developing has anything to do with the level of competition.
Okay.
I think it is largely to do with the capacity to
Yes,
enforce something as vigorous as a digital competition bill. I think let's bring back the focus there. I don't think it is about the level of competition as opposed to whether our state capacity allows us to enforce something like the draft digital competition bill meaningfully.
Thanks, Manjushree. So let me ask Rajat something which was briefly mentioned as at least as a phrase, a word I would say by Archana earlier in the discussion, which was about not only about competition but actually about market contestability. So because a lot of times people sort of talk about that. So if you can briefly address that, and then I'll move over to Sridhar for something very quickly on AI. There are a couple of things, and then we'll just close that. Yeah.
So contestability is, I do want to address Lavish's question also.
Yeah.
So after I answer
Sure.
this question, if you permit
Okay.
me, I want to sort of also answer Lavish's question. So contestability is something that, often the Americans, and I'm using this word
Yeah.
advisedly, right? The Americans would say, you don't need to do anything because the market is contestable. And in the famous AT&T divestiture case, which you mentioned, they said that, look, while it's a big market, we are actually contestable and we are a natural monopoly because we are providing services to at the lowest possible prices. Now, that was, of course, a self-serving argument. I think contestability in the digital space is both yes and no, right? Because all these big techs, like Dhanendra was saying, I mean, they're bigger than countries put together. So in terms of contestability of the market, it probably is not there.
Okay.
The market is not a contestable market. You would think it's a contestable market because anybody can get it. But the moment you start doing business, it's very difficult. And what do these guys do? They raise the rival cost of doing business. They acquire the best people. Google has acquired the best engineers. They've acquired the best programmers. They've acquired the best office space. So how can you compete with Google? Okay. So having said that, let me also say, I think as a part of this discussion, is that while digital markets are not contestable and it's difficult to sort of break these monopolies, what is the success of breaking up a monopoly or sort of control, not breaking up, or managing? You can't control a monopoly, as I said. They're abusive and they will continue to be abusive. And they will exploit and for whatever reasons, profit making, long-term profit, present discounted value, whatever. So, but what our objective is not as regulators, I'm putting myself as a regulator, as regulators, the object is not to sort of control them, it's to manage. And where can competition come from? It can come from multiple sources. And no one instrument is going to be sufficient to control any of these monopolies. So whether it's a behavioral remedy, cease and desist, banning exclusionary contest, banning time, structural remedies, trying to incentivize competition from an unlikely source like ChatGPT happened on its own. Like Dhanendra said, you could inspire something. UPI is inspired. And UPI, I think, is a great model. It's a very, very good model. So let me answer Lavish's question. And it's an interesting question. It's a sort of political economy question is, why aren't public sector entities regulated the same way as private sector entities are regulated? And what is, why hasn't that happened in India? And I think rather than making a sort of a judgment on it, at least I can sort of, as an economist, diagnose why it has happened. Culturally, whatever, the way the regulator evolved, I'm very close to TRAI, the way the TRAI, well, I was probably one of the few people along with Harsh who was outside of the government system. Everybody else was a part of the government system. And the way it has evolved is that they have secondments from the government, not secondments from the private sector. After the American experience, I don't know whether secondments from the private sector is a good idea or not. So I have my doubts. But the point is that Should it be arm's length? Yes, it should. Why hasn't it happened in aviation? It hasn't happened. When Air India was, it wasn't regulated by DGCA. BSNL, MTNL have not been regulated by.
Right, so
I don't know. I mean, they should be, but they don't participate in spectrum auctions. They're given spectrum.
and then they return it back.
And they give it back. So it's, I think, sort of much more of a cultural, I mean, the way it's evolved, but I think that, or the bigger question that Rakesh has left here, Rakesh would have asked is, why is BSNL continuing to operate?
Or not operate.
Or exist? Why doesn't it sort of move to the private sector or disinvest?
Okay.
So on. Yes.
So she a couple of quick things. So, and both of one is from Anupam Khanna, as you know. So this is basically about AI. So he's saying that what about open source ecosystem around AI and technology based approaches? For example, Apple's rule change and its impact on Meta and social media a few years back. But the fact is, Meta, again, their revenue as well as profitability has actually gone up. Of course, initially it did have some impact a few years back. The other one is from Mr. Shambhudat Sharma, retired IAS officer, which is also about AI and competition law interface. And although he's saying that he is going to send us a detailed note separately, but basically he's also looking for some framework, both legislative and administrative. So can you share some quick reactions to these?
Yeah, quick ones on AI. So definitely we have the AI EU regulatory guidelines on transparency, verifiability, explainability, safety, security of systems, and so on, right? So recently, I mean, yesterday, California passed the AI Safety Act, right,
yes,
which promotes safety of the AI models. Now, there is one thing to talk about for example, safety, security, and explainability. And you are assuming that in the case of an open AI model, it will be transparent, right? But the important thing is in open AI models, they are foundational in nature, and therefore they collect data from everywhere, and then they present it in a way which is sort of consumed by consumers. Therefore, it is maybe very difficult for us to regulate foundational models, such as, for example, Meta's Llama 3.1, which basically gets the data from anywhere and everywhere. But it is possible to regulate certain vertically focused platforms which are built over the foundation models. So for example, somebody is building an AI model for autonomous vehicles. Then it is possible to enforce, for example, AI security and safety standards for that particular vertical AI model space. So that is how I envision, for example, the AI regulation to sort of evolve in the future. AI for healthcare. You can put in some stringent conditions as to what it should do and what it should not do. And it can be ex ante, because we know what security means. For example, the killer switch, which has been proposed in the California AI Act, everyone is opposing, but that's a good thing, because if something goes wrong, you press the switch and kill the model.
Okay. Thanks, Sridhar. By the way, he just mentioned about this whole thing about LLM, etc. Technically speaking, one of the IETF, which is the Internet Engineering Task Force, so one of their RFCs, so the same RFC which is used for online search crawlers, through which they sort of collect the data, is also being used for AI LLMs. And this is a very technical issue, and this is, however, being debated right now at IETF. So 16th August was the last date for their submissions. They had invited some comments. Apparently, only one has gone from India so far. And next month, there is a 2-day workshop at IETF. So let's see what comes out of that. But at this point of time, let me just stop the discussion. I'm seeing the clock also. We are already a little past behind this. And thanks to all the panelists for their frank, candid, and at the same time informed sort of comments. We will be proceeding further and sort of looking into these issues a little bit more further, and we might trouble you again with that. Also, thanks to all the audience, I just request Bhavna, my colleague, to sort of propose a formal vote of thanks.
Hi, everyone. Firstly, I would like to thank to all the speakers for giving your time and sharing your knowledge and expertise. And then, of course, our wonderful audience, the participants in person and online. And then our moderator for keeping our session so inquisitive. And then, of course, our chairman, Lavish, for pulling, of course, for guiding us to organize the event. And yes, finally, I request you all to please join us for some tea and snacks outside.